Hi, everyone. My name's Amrit Kaur Khalsa. I'm an attorney here in Anchorage. I've lived here since I was 7. And I have been doing family planning for families with children with special needs for about 30 years. And I have put together a PowerPoint that we'll go through. And I actually set up a place for questions at the end of each different type of trust. So the trusts are intended to allow the beneficiary to be eligible for SSI and Medicaid. And so there are the resource asset eligibility general rules I have here that Alaska Medicaid generally follows the same resource rules as SSI, though the rules vary for some types of Medicaid plan programs, such as working disabled Medicaid. Generally, single people are only allowed $2,000 in countable resources, and resource eligibility is determined each and every month the recipient is receiving Medicaid. And if you've looked at the forms, there's the duty to notify Medicaid if there's going to be an asset received that will change resource eligibility. The eligibility is determined literally at 12:01 a.m. on the first day of each and every month. And so any kind of spin down or treatment of the asset has to happen by the close of business on the last day of the preceding month, or really by midnight on the day preceding the first of the month. Otherwise, you have to wait an entire month before you're resource eligible again. So there are a number of assets which are considered exempt resources and don't count against the $2,000 limit. This includes the applicant's home with any adjacent lots. So if they own their house and 2 lots next door, something like that. Household items and personal effects are generally excluded unless they're a collection that was held for investment, like an art collection or Alaskana collection, coin collections, things like that. One automobile of any value is excluded. Life insurance policies with a face amount of no more than $1,500. So if you bought a whole life policy for your child when they were young, or there was some policy that has cash building up inside it, which is what whole life policies do, then that would have to be dealt with because of the remote resource. They can have a burial account of $1,500 plus any interest that it accrues, a burial space or plot intended for use by the applicant. They could also buy a prepaid burial plan that covers some of these expenses, which is, if it's irrevocable, it's not counted as a resource. If their person's not on SSI, the PFD is also an excluded asset if it's kept in a separate account so that it's readily identifiable. And then for Alaska Native families, there are additional exempt resources and assets. There's the actual stock, ANCSA stock is exempt. Up to $2,000 of dividends are excluded each year, both as income and as a resource. They preferably you keep those in a separate account, but if you don't, the assumption is any withdrawals from an account where they were deposited were of the non-exempt funds first. But if you have a separate account, then you can save $2,000 a year in that account, and you may, so every year, after 5 years, you've got $10,000 in there. And these accounts are inheritable without a state recovery from Medicaid. So taking advantage of them is a good idea. And then for long-term care Medicaid, all real property in Alaska owned by an Alaska Native or American Indian is excluded, regardless of whether it's restricted or unrestricted. But for APA-related Medicaid, the Alaska Native-owned land must be federally restricted to be exempt. So there is a difference between the two Medicaid programs. So if someone's on a waiver, real property is exempt, but if they're just on APA-related Medicaid, it's not exempt. And so I was going to pause to take any questions on resource eligibility at this point.
Amrit, we don't have a question about resource eligibility, but someone did ask if your PowerPoint would be available after the lunch and learn.
Yes, I'll send it over to Lisa, and then she will share it with everybody that's here.
Okay, thank you.
Okay. So now I'm going to go through the main types of resource eligibility issues, or vehicles to deal with resource eligibility issues to get someone under that $2,000 resource limit. So for persons whose disability began before age 26, they're allowed to set up an ABLE account. If for someone who was disabled at any age, but it's so long as they're under 65, so literally on the day of their 65th birthday, they can no longer create these accounts. There could be a special needs trust set up to hold their assets. It could, under federal law, it could be created by the individual, their parent, the grandparent, the legal guardian, or the court. And pooled trusts are for Social Security disabled persons of any age. So if you're dealing with someone who's 65 or older, their option is a pooled trust if they have a Social Security disability determination. Okay, so ABLE accounts. These are the details on that. The disability or blindness began before age 26, and disability can be established either by Social Security, or the individual can certify that they have a medically determinable impairment that began before age 26. So if you don't actually have a Social Security disability determination, they may still be eligible to use one of these accounts so long as the condition began before age 26 and they could document that. Currently, the annual amount that can be deposited in an account is $15,000 per year. And when I say from all sources, that means like if the beneficiary puts in money, and a parent puts in money, and a grandparent puts in money, all those sources combined cannot exceed $15,000 unless the ABLE account owner is working. And in that case, they can deposit their earnings, an additional $15,950 per year of their earnings can be deposited into an ABLE account. Generally, they're used, and that number, the $15,950, I noted in parentheses, that's this year's number, and it goes up a little bit every year. That number's in the Medicaid manual online, the Adult Public Assistance Manual. And generally, these are used for, besides earnings, for permanent funds, gifts, small inheritance, maybe a small personal injury settlement, someplace where not enough money is coming in to make it really cost effective to set up a trust. And the amounts in this account will not interfere with Social Security, SSI benefits, up to $100,000, and a balance, so up to $400,000 for Medicaid. If they're not on SSI, then they can have the additional monies. But as with all these kinds of Medicaid resource eligibility vehicles, Medicaid is only ignoring the assets while the person is alive, and at their death, the funds would go to reimburse the estate for Medicaid services provided. Now, the ABLE account has a broad definition of qualified disability expenses, and you'll see number 2 includes housing, which if you're familiar with other trusts, and we'll go through them after this, that they don't allow food and shelter expenses generally to be paid. And so the ABLE account has more flexibility on what the assets can be expended for. So someone who was disabled before age 26 has more flexibility on how their money can be used. And this is the general rules. There can only be one account, so you can't have multiple ones for the same beneficiary. And you can't just go to First National or Credit Union One and open an account. It has to be administered by the ABLE administrator that the state of Alaska is contracted with. I got the link to the site there. It's the First Third Bank, I think, is the name of the contracted ABLE account administrator. And then common sense distributions can only be made to or for the benefit of the beneficiary of the account. The beneficiary can be a signer if they have the capacity to manage their own funds. So this can give them access to a savings account that gives them the ability to purchase some things without having to ask a trustee for money or for the trustee to purchase it. And these, we're frequently now using them in conjunction with the first party asset trust discussed below to allow more flexibility, as I said, in the types of expenses, because the shelter expenses can be paid, and for who could pay them, again, letting the beneficiary have access to their own money. Okay, so questions about the ABLE account?
A question that we have in the chat box asks if inheritable funds count as exempt or as assets.
No, inheritances are 100% countable. So they are not exempt. They have to be, you don't have to report them as soon as the person dies, because normally it takes time before an estate is processed and the money becomes available. But if it's like a life insurance benefit or a retirement plans are a completely different conversation. But if it's like life insurance or something that is going to pay directly outside the probate, then that rule that you have to report to Medicaid the changes of asset amounts within 10 days of receipt applies. So for estates where it may take several months, you don't need to report until you're about to receive the distribution. And that's normally when I become involved, is people realize they're going to get an inheritance, and we have some time, normally several months, we can sort out what they want to do and get trust set up or ABLE accounts set up to hold the inheritance. But it's definitely a reportable asset. I see another number popped up in the chat. Does that relate to this?
They just said thank you.
Oh, thank you. Okay. All right. So that's all. We can move on to the next one.
Yep.
Okay. So the next type of trust, which is the one most commonly used for like personal injury settlements and large inheritances, is a qualifying asset trust. And so the general rules here are that the trust must make expenditures that comply with income and resource rules. They cannot provide basic support without the SSI rule for in-kind support and maintenance coming into play, which then would reduce their SSI benefits by a third. Though frequently that decision is made to take that reduction because the benefit to the beneficiary is more than the loss of a third of their SSI payment. The definition of shelter that SSI uses here is very specific. You see, it doesn't include things like telephone, internet, cable, that sort of other regular monthly expenses. And as noted in the last bullet, it can pay for, recreation, entertainment, education, therapies, any kind of services that would have a direct benefit to the beneficiary. So the irrevocable asset trust or first party special needs trust can hold real and personal property. We also use them. I noted the Social Security back pay. If you have someone who gets a large lump sum of Social Security benefits when they apply following a disabling event, they have 9 months to spend it down. And if they don't have anything to spend it on and don't want to just kind of squander it, they could put it into one of these trusts. But they're required to be for the sole benefit of the disabled beneficiary. So it can't be a trust for like a brother and a sister. They would each have to have their own separate trust. And the Social Security definition of disability, again, is required. And the most recent redetermination date must actually be put in the trust document. That as an attorney drafting these trusts, that is generally the most difficult piece of information to obtain, is the most recent redetermination date. And Medicaid is able to apparently access that date from a link it has with Social Security. So they know the day they're looking for in these trusts. And so, as I mentioned earlier, these no assets can be added on or after the 65th birthday, but any assets that are already in the trust can remain there indefinitely. They could continue to earn interest, dividends, be expended for the beneficiary's benefit, but you can't put any money in there after age 65. And these are first party trusts because they're funded with the beneficiary's own assets, not with someone else's assets. Now, for another option of these Medicaid qualifying trusts is a pooled trust. And these are available to people both over and under age 65. The pooled trust is run by a nonprofit organization that has a different account for each beneficiary, but they pool the accounts for investment purposes. And that's why it got the name of pooled trusts. And so, again, they can be opened by an account at a nonprofit, can be opened by the individual, their parent, grandparent, legal guardian, or the court. And the difference between the first party trust, which pays back Medicaid when they die, is when the beneficiary of a pooled trust account dies, there is an option for the funds to be retained by the charity rather than being repaid to Medicaid. But if they don't have all the funds go to the charity, then the remainder of the funds would go to repay Medicaid. So in Alaska, we have only a couple of options for non-OPA clients. So the foundation of the ARC has a pooled trust fund, but the person has to have a disabling condition within the ARC's charter. So it isn't eligible. People who aren't suffering from that sort of disability aren't eligible to join, just like an elderly person who was disabled before age 65 gets an inheritance, but they're not eligible to join the ARC trust because their disability isn't within the ARC's charter. So one of the companies that has registered with Alaska Medicaid is Secured Futures Trust, and I've got their website information there, and they provide these pooled trust services for Alaska residents. And OPA clients, OPA maintains a pooled trust only as law, and their clients can be members of that. But if they leave OPA, then they have to move their pooled trust assets to another pooled trust or to a first party irrevocable asset trust. Okay, now there are also Medicaid qualifying trusts that don't have to pay Medicaid back, but these have to be created by someone other than the beneficiary with assets that never belonged to the beneficiary. So these are what, as an estate planning attorney, I do for parents that, or grandparents, that you set up a trust for your child, that their share of your estate goes into that trust. And so by doing that, the child never gains ownership of the asset and is allowed to. So then the trust does not have to pay Medicaid back. You, as the creator of the trust, basically are giving a life estate to your child. And at the child's death, the assets will pass to whoever you name as the successor beneficiaries. And because these are not created with the beneficiaries' assets themselves, they're not subject to the age 65 limit. And so I actually use these for long-term care Medicaid planning when an elderly person or even a younger person has a stroke or some other incapacitating illness. We can transfer assets through a two-step process into one of these trusts and gain eligibility for Medicaid. So even being age 65 does not come into play here in terms of restricting the ability to use it, as long as it's not the beneficiary's assets going directly into the trust. Again, the trust document itself still limits distributions of income and principal to maintain the public benefits, and it has more flexibility in terms of allowing the trustee discretion to maybe pay for a family vacation, whereas under a first party trust, only the beneficiary and a medically necessary companion could have a vacation paid for by the trust. We use these now frequently to fund ABLE accounts for the qualified beneficiary so that they have more flexibility, again, to use trust assets by putting them into an ABLE account first. They're able to be used for shelter and basic living expenses, which the trust doesn't normally pay for. And again, these are called third-party special or supplemental needs trusts. Okay, so that's the end of the section about resource qualifying trusts. No questions? Too many questions.
No questions yet in the chat box.
Anybody thinking? All right. So the last kind of trust, because Medicaid has two prongs of eligibility besides the medical level of care, they also have income and income eligibility. We went over the resource or asset eligibility, but the second financial prong is income eligibility. And so these are commonly called Miller trusts, but they are available only for income eligibility. They're not for the excess assets or resources. You have to use the irrevocable asset trust or pooled trust, that we talked about above. They can be used for all types of Alaska Medicaid, but they cannot be used if you are receiving SSI. They cannot be used to keep your SSI if you get extra income, and they're also not used for APA cash. So basically, Miller trusts are intended for people whose income is over the limit for the program, and if you're on SSI or APA cash, those numbers are under the limits for the Medicaid programs. Unlike the asset trusts, which I mentioned have to be funded, or asset eligibility is determined at 12:01 a.m. on the first day of the month. And if you're over resource on the first day, you're ineligible the whole month. But a Miller Trust can be established and funded any time during the month in which income eligibility is sought. And if you think about it, it makes sense because people's checks arrive all different days of the month. And so they can't put the money in the trust before they actually have it in their bank account. And so the Miller Trust could be retroactive. If they're resource eligible, it could be retroactive to the first of the month that it's established. Now, when you see the trust, they're called irrevocable income trusts. And so frequently the question comes up, am I giving my income forever? What if I go off of Medicaid and it's not a permanent assignment? If you stop using Medicaid, then you just stop funding the trust. But the money that's in the trust already will, if you're terminating the trust completely, go to pay Medicaid back at that point. You can just suspend using the account, and the money would stay in there until you die. And then at that point, it would go to repay Medicaid. For the Miller Trust, they have very specific rules about how the money can be spent. With the asset trust, there's more like general statements of what you can and can't do. But with the Miller Trust, Medicaid's pretty specific. There's basically a personal needs allowance that is intended to cover food and shelter expenses and any other personal needs like clothing, haircuts, toiletries. So the beneficiary has to have their own account. You can't, even though their income's going to change to be deposited into the Miller Trust, they still have to have a personal account that their personal needs allowance will be transferred back to every month. And then they can pay the food and shelter and other expenses from there. And that personal account is subject to the $2,000 resource limit, whereas the Miller Trust account does not have a resource limit. I had a client with $45,000 in his Miller Trust account, and we bought him a pickup truck. And so you don't have the resource limit on the Miller Trust account that you have on the personal account. And the personal needs allowance will vary depending on the type of Medicaid. So for basic APA-related Medicaid, where you're not seeking adult public assistance, the income limit for 2021 is $1,474 a month. And so if you have a disabled child who starts to get survivor benefits or adult child benefits on a parent's record that pushes them over that amount, then they would need to have a Miller Trust to maintain their eligibility. I noted that for residents of ICF and MR institutions, they increased that $1,474 amount would be increased by an amount needed to fulfill an approved plan for achieving self-support. And then for the long-term care waiver and nursing home Medicaids, the PNA is also approved, increased to approve a court-appointed guardian for up to $100 a month to pay income taxes and to pay child support obligations. Then there's what happens with the money that's not dispersed back to the beneficiary for their personal needs allowance. Then again, it depends on the type of Medicaid that the person's on. For adult public assistance related Medicaid, the money can be used basically for any non-food or shelter expense. But note, it has to be paid directly to vendors and not to, it can't be given to the beneficiary then to pay the expense with. It has to be paid by the trustee directly to the provider, the vendor. For waiver and nursing home Medicaids that have the cost of care obligations, the trust disbursements and the over and above the personal needs allowance are spelled out in the Medicaid rules. And so if they're married, there's a spousal allowance. If they have minor and dependent children, there's an allowance for each minor independent family member. And other generally allowable expenses are insurance premiums, unpaid medical bills, taxes, child support, and for a single person, their home maintenance expenses. So if they're living in an assisted living home or a nursing home, they're only allowed funds to maintain their own home for up to 6 months, if and only if they also have a doctor's letter saying they're likely to be able to return home. Otherwise, they are not going to be allowed any money to pay utilities, taxes, insurance, mortgages, that kind of thing. And then, because lawyers are everywhere, our attorney fees are allowed to be paid out of the Miller Trust, as are accounting fees. If there's enough money in the trust that there's tax returns being filed every year, then there would be accounting fees could also be paid. But generally, these accounts are emptied out unless you're on APA-related Medicaid or a waiver program without a cost of care obligation. And then in those cases, the trust can get substantial enough where they may have tax returns. Okay, so any questions about the Miller Trust?
Yep, there is one question. The question asks if the Miller Trust is irrevocable.
Well, that goes back to where I mentioned, and maybe they asked the question before I got there. Here, the beneficiary, it's irrevocable only month to month. Is not a permanent assignment of income. So yes, it's required by the laws and regulations to be irrevocable, but you basically revoke it by stopping to fund it. But any funds that are already in there have to stay in there and be used in accordance with the rules. Yeah.
Any other questions?
Because actually I'm really done. And then I have like this little 1-page slide that kind of gives you a snapshot of each of the types of trusts and the ABLE account.
As always, we appreciate your knowledge that you share with us and support. Feel free to visit our website for any of our Stone Soup Group's trainings. They're recorded and put under our training section. There's a lot of great trainings on there.